Well, welcome everybody. I'm delighted that you've all been able to attend this session this afternoon. This is an event organised by the International State Crime Initiative, which is a centre based at the Queen Mary University of London Law School. And this event is in conjunction with War on Want. And we're really thrilled to be able to introduce a panel today, which will be, the panel will be discussing a really important report that has been produced by War on Want, Judge, Jury and Occupier, Israel's military courts in the occupied West Bank. We've got a fantastic panel that I will ask Nadra Shalhoub-Kevorkian to introduce in a moment. But just to say that Nadra, the chair, is a member of the Queen Mary University of London Law School, and we're absolutely delighted that she is. So I'm very happy to welcome you both as Director of the International State Crime Initiative, but also as Head of the Law Department at Queen Mary University. We hope you enjoy today's session. We hope that you become more involved with us. Please look at the links which will be in the chat if you want to know more about ISKI's work. The report will also be linked in the chat. So thank you, and I'm going to hand over to Nadra now. Nadra, you're on mute.
Can you hear me? Yeah. Okay, so good evening for those that are joining from London and from Palestine, and good morning for those joining from New York. My name is Nadra Shalhoub-Kevorkian. I'm a global chair in law at Queen Mary University of London. We at the International State Crime Initiative, ISKI, are really delighted to host the launch of a new report from War on Want, and discussing featuring experts on the issues related to Israel's system of the military court. Let me start by just giving you a brief on the Israeli military court. Is really one of the central subjects that govern the lives of Palestinians. The military court system is an institutional enterprise of the Israeli settler colonial apparatus, lying figuratively and literally at the center of the conflict. It stages the legal system and its court as a major site of settler colonial dispossession, and of course all done legally. And we all know that colonialism was done legally. When publicly discussing the military court, Israel's tradition usually is shaped and justifies its policies through legal argument, legal institutions, and legal professionals, and we can see that clear in the writing of various scholars. You know, Hedi Vuturbo, for example, reveals how the Israeli military claims that military courts pertaining to minor are established in accordance to international law, and it makes really major efforts to protect the rights of children, but we know exactly what lies underneath it in what is framed as the best interest of the minors. Scholars such as Lisa Hajjar have examined the Israeli military court, insisting on our role to pose critical questions such as why and how was it created, what purpose does it serve, how does it work, what happens in its setting and why, and how does the Israeli military court connect and nurture the broader context through the military court. Yeah, so the court system is part of the Israeli military administration. It aims at controlling the Palestinian residents of the West Bank and Gaza, when the Palestinians living in these areas are an occupied and colonized population, and Israel is not their state, yeah? And they have no sovereign state, but are living their lives under an accumulative dismemberment, state criminality, and unending dispossession, attacking life and land. Although there have been changes in the political situation for some people that are looking at the administration of the West Bank and Gaza, mainly if we're looking at the 90s, since the 90s, and the establishment of the Palestinian Authority in 1994, Palestinians remain occupied and stateless, and Israel remains the de facto sovereign. And if I look and share with you perceptions of, for example, Lisa Hajjar, scholar Lisa Hajjar on military court, I want to quote, the military court primary purpose, as Dr. Hajjar states, is to prosecute Palestinians who are arrested by the Israeli military and charged with security violations and other crimes. The military and emergency laws enforced through the military court criminalize Palestinian violence, as well as wide area of other types of activities, including certain forms of political and cultural expressions, associations, movements, and nonviolent protest, anything deemed to threaten Israel's security or adversely affect the maintenance of order and control of the territories, end of quote. Having this event to discuss the military court can really help us see how law is enforced and what is done or not done in the name of the law. So the publication, Judge, Jury, and Occupier, Israel's military courts in occupied West Bank, really takes us to look at the Israel's military court, military orders, arrest, and detention, which Palestinians in the West Bank have been subjected to since the beginning of the occupation. The report really looks at the court not simply as flawed judicial mechanism, but as an integral part of an illegal occupation. So to just give you some details of the event, because we have really an amazing group of scholars and activist lawyers here that have worked for a long time in looking closely at the issue of military court. Just let me give you some details about the format of the event. The format of the event will be like an interview style. I will ask 3 questions to each speaker. Speaker will respond in about approximately 5 minutes with the hope to leave 20 minutes for questions from the audience. Okay, so let me start by introducing the discussion with the different panelists. I start with Advocate Sahar Francis. Sahar Francis is a long-time activist, amazing person working in the field, an attorney and director of Adamir Prisoner Support and Human Rights Association, a Palestinian non-governmental civil institution that works to support Palestinian political prisoners held in Israeli and Palestinian prisons. And you will have the connection to Adamir via the chat. We're very delighted to have Professor Michael Link. And Michael Link is the United Nations Special Rapporteur for the situation of human rights in the Palestinian territory, occupied since 1967, and Associate Professor of Law at Western University in Canada. His work and their website is absolutely very informative, very important, and it takes a different, really sharing different insights in looking at the situation. Shishi Chi is Militarism and Security Campaigner Officer at the London-based Anti-Poverty and Human Rights charity War on Want. Ms. Chi researched and wrote the Judge, Jury, and Occupier report. So let me start with Chichi. Can you please limit your response to 5 minutes? And let me ask you the following. You've researched and written this report. What are the main themes that have emerged out of the report?
Thank you, Nadara, for that wonderful introduction. And yeah, as you said, one of the main things that came out of this was that the military courts serve the function of perpetuating a military occupation. So they operate as a central tool of the occupation regime, and they are not a justice mechanism like we think of justice mechanisms. A system that is designed to deliver procedures of justice and accountability. They are purposely repressive of the Palestinian population. So they specifically function to uphold the occupation through criminalizing dissent and deterring any resistance to military rule. So I'm going to highlight 3 major themes and takeaways from the report. So the first one has to do with the massive scope of military courts and the way that they impact all of Palestinian society in the occupied West Bank. So the military courts, they're not just used for some offences or only used in very exceptional cases. They are used for the entire Palestinian population in the West Bank. This is like some 3 million people who are all subject to military rule and therefore subject to the military courts. This includes children, as you mentioned, who are also arrested and tried in military courts. And even though international humanitarian law asserts that civilians should not be tried in military courts, aside from very exceptional cases and circumstances, despite this, the trial of Palestinian civilians in Israel's military courts is a regular and routine part of life under occupation. They're used in such a sweeping way that every Palestinian family in the West Bank has been affected by this system. So the widespread use of military courts on Palestinian civilians shows function as part of a broader system of political repression. And this is like the second main theme I want to talk about. So the Code of Law under Israel's occupation is a list of military orders, and now there's over 1,800 of them. These military orders have been accumulating since 1967, and they cover almost every aspect of life. So there are military orders that ban the possession of political pamphlets, that ban holding unauthorized meetings of more than 10 people, of participating in peaceful demonstrations, and even waving the Palestinian flag. Over 400 Palestinian organizations are technically prescribed under Israel's military rule, a list that includes all of the major Palestinian political parties, as well as student groups and other civic associations. So the kind of groups that should play an active role in any free and civil society. The scope of the military orders and the very oppressive ways in which they are enforced essentially criminalize all forms of political and civic expression. In this system, the entire Palestinian population is merely treated like a potential security threat to Israel, rather than as civilians with civil and political rights. One example of this repression is the way in which Israeli authorities use arrest and the in military courts to crack down on protest and activism against the occupation. So, for example, by declaring that an area of protest is a closed military zone and making anyone in the closed military zone subject to arrest and trial in a military court. This doesn't just deny Palestinians' right to civil life, but and extend occupation by delegitimizing any form of resistance and punishing political activism. The Israeli authorities claim that this is about security, but they use this justification of security so widely and so broadly that it essentially refers to anything that poses any kind of challenge to occupation. But it's not also just political activity or protest that is targeted. So I was very struck when conducting the research for the report that something Ademir has actually talked about, which is that 40% of charges from the military courts each year are for traffic violations. This shows how the narrative of security, which Israel pushes with the military court system, is false even by its own standards, and so how occupation is enforced through the imposition of a colonial order into everyday life. So the last thing I want to talk about is the totality of the military court system in violating the rights of Palestinians. So the violations in the military court system are not just frequent, they are built into the system itself. This includes a complete denial of fair trial guarantees, routine use of torture and ill treatment during interrogation, to illicit confessions that are then used in trials. And these are just some small examples. The violations are completely endemic and they are built in from the beginning to the end, and they have been systemic for decades now. So it's not just the operation of the military courts that's the issue here. It's not just a question of some inadequacies or procedures that can be improved. The military courts are part of the occupation infrastructure as much as visible instruments that we can see, like the apartheid wall and checkpoints or illegal settlements. These are physical manifestations of colonial violence. The military court system is the legal manifestation. It is coercive, it constrains the lives of Palestinians, and over time, it has attempted to transform Palestinians into occupied subjects only, stripped of their civil and political rights, and only existing in relation to the occupation. Of course, Palestinians have always resisted this, and active Palestinian civil society, including amazing human rights organizations like Ademir, are a testament to how Palestinians have not given up on their inalienable rights. I'm going to end my comments on that note. So as much as the research for this report was upsetting and very dark, I came away from it in awe of the incredible work that Palestinian human rights groups are doing and of all of Palestinian society's pushback against this repression. And for War on Want, we are also, like ourselves, consider ourselves very lucky to have the opportunity to work with groups like Occupier, to learn from their research and advocacy, and to keep raising these issues with the UK government, to raise the issues of British obligations and what responsibility we have towards the Palestinian people as much as we can. Thanks.
Thank you, Gigi. Thank you. It is really the scope, the amount of oppression, the silencing of dissent, and everything in the name of security and the totality that you have referred to. And I think that one point that I can see clearly in the report was the fact that you're shedding the light on the everydayness of such an effect. It's not only the legal issue, it's how this legal issue is really affecting the everydayness of life, of marriage, of and so on. And here I move to Sahar and asking you for Adamir, because you're working in the field for a long time. What are the most pressing legal issues that emerge in the context of the Israel's system of military court? Mainly, if you can really try and focus on what is going on, especially the past couple of years from your experience. How is the scope translated? How is the oppression explained? And how is this totality, marking the lives of Palestinians?
Good evening, and really it's very important, and thanks for the organizers and for the presence of Professor Michael Link with us today. It's really an honor to be with you all. As you mentioned in your introduction, Nadira, and that was followed by Chichi presentation about the structure of this military court system. And the main aim is to maintain the control and the oppression over the whole society. And it's covered by this claim that the purpose of this system is to protect security or to prevent future crimes that is supposed to be committed by the Palestinians. Actually working there day by day, it's a very, very difficult experience. And I think there's lots of details to be discussed within this system, whether the jurisdiction, as which crimes fits under this system, the geographical jurisdiction of this system. But I think it's very important to explain a bit and to fit more into what you were introducing, both of you, before. For example, if we take the issue of administrative detention, how they legalize this process of arresting people without any charge, without any evidence, based on secret information, actually. And they were doing it since the beginning of the occupation. Hundreds of thousands of Palestinians were arrested under this policy of administrative detention, which enables the military governor to arrest anyone for up to 6 months based on this secret information, claiming that he's imposing a threat to the security. By the way, it includes children, and we have currently few children arrested under administrative detention for up to 6 months that could be renewed indefinitely. How you are supposed to defend such a person or to exhaust the procedures in this system if anything is justified by security under secret evidence? Me as a lawyer, I don't have access to it. I'm asked to defend someone that actually I don't know what's the exact accusation against him and how to defend him. The arrest of children by this system that for so long years, up to 2012, actually, they were not recognizing Palestinian children as people who are under 18, but just under 16. And they were treating Palestinian children between 16 years old and 18 years old as adults. And of course, children could be subjected for all methods of torture, solitary confinement under interrogation for long days, and obtaining their confessions by torture, then charging them and accusing them based on these confessions taken by torture, and would be sentenced for long period, including 10 years or 12 years or 14 years in prison with very... So, I mean, the system is not just that is not guaranteeing fair trial standards, but there's a main problem with the definition of the crimes that is brought under this system. As Chechi mentioned, it's not just that 40% are not related to security at all. There's also the other cases, thousands of cases of workers, Palestinian laborers, workers that they enter Israel without a permit, and they would be prosecuted in this military court with the traffic issues. So if we take the average of the last couple of years, more than 60% of the cases that they were dealt in this court were about traffic issues and entering Israel without a permit, or other usual criminal cases that is not related to security at all. So this explains how they use the cover of security actually to justify criminalizing every aspect of our daily life. Add on top the issue of arresting political activists, political leaders, students. Lately, they were illegalizing studential movements in the last summer in order to justify arresting tens of the students in Birzeit University, sending them for 1 year, 1.5 years, in some cases 2 years, because of their activism inside the university, not threatening directly the security of the state at all. Like, to explain more about how they justify everything by law. For example, the incitement issue. Publishing your political opinion or your opinions in general in Facebook, in any of the social media, in most of the cases would be considered a crime of incitement, and you would be imprisoned for daring to share a poster or a picture or an article or whatever, if it's associated with one of the political parties or the organizations. And there's hundreds of organizations, parties, groups that they are declared illegal by the Israelis. The last point I wanted to end with is the issue of the torture, because it's very, very essential in the work of this system. At the end of the day, most of the Palestinian detainees are subjected for one method or more of torture and ill treatment, whether in the process of the arrest or later in the interrogation. Most of the evidences actually are based in this system on the torture. And to remind people, Israel actually in the 1999 decision by the High Court kind of legitimized the use of torture by giving this protection for the interrogators of the necessity defense, which means that they can torture people and without being accountable for this torture. And actually the whole process could be built on the outcome of the torture, and people could be convicted based on evidences that were collected by torture. Of course, in the procedures itself, when the military judges extend the detention of the detainees and they are aware that they are facing torture and ill treatment, and they continue in the ban orders for the legal counseling in this sensitive period of the interrogation, actually they are complicit. So the whole system is built in a way that it takes us to one place where there's no chance that you wouldn't be convicted under this system and accused of being a security threat and charged for long years in detention.
Thank you, Sahar. You really put your finger on different issues that I would like us to go back to them, especially the issue of secret and the secret information. The fact that you mentioned how evidences are really are collected through torture, and what does it mean legally. But I want to really move to to Michael and to first ask you to discuss with us, because you've really written at length to those different issues and through your role as a special rapporteur, and you've argued that Israel's occupation has crossed a line into illegality. Can you please elaborate? And I was wondering whether you are willing to even put on the table something related to the abolitionism that we are seeing, the abolitionist approach that we're seeing in other places. But can you really elaborate on this issue, this point, and discuss how the military court fits into this analysis of your framing of crossing a line into illegality?
Sure. Thank you very much. And if I can start off by saying it's an honor to have been invited to speak on this illustrious panel, and I also want to give my obviously my highest regards to the indispensable work that Ademir and Zahir Francis have been doing, and also compliments to War on Want for its incisive report on the military courts. This adds greatly to our understanding of the various mechanisms of this forever occupation. As you've mentioned, Nadira, in several years ago, one of my reports to the Human Rights Council explored the issue of whether or not an occupation can become illegal. And in particular, has this occupation, at that time, I think it was around 50 years of occupation, now almost 54 years of occupation, has that crossed the bright red line into illegality? And remember, the assumption in international law, there's two main assumptions when it comes to occupation. First of all, an occupation is meant to be temporary, that the occupying power claims no sovereignty and is to withdraw at the earliest possible time. And secondly, that occupation is in fact a legal regime when it is introduced through military war and belligerent occupation, that the occupier is deemed to be a lawful occupying power if it obeys the rules of international humanitarian law. And that's what the world has assumed with respect to the Israeli occupation. What I argue in this particular report is that while the international community has taken the view that many aspects of the Israeli occupation have become illegal, the placement of the separation wall, the settlements, the annexation of East Jerusalem, aspects of the military courts, in fact, it has not come to a unified conclusion that the occupation itself has become illegal. And what I argue in the report is I said, look, there's several measuring points that you have to wind up using with regards to this to determine whether or not an occupation has turned that corner from legality into illegality. And what I do is, by going through international humanitarian law, I point out four particular tests. First of all, I say that very clear in international law that the belligerent occupier cannot annex any of the occupied territory. The very famous statement by one of the founders of international law a century ago, Oppenheim, said that occupation does not give you the authority to claim sovereignty over even an inch of the occupied territory. Secondly, the rule is that the belligerent occupation must be temporary, and it cannot be either permanent or indefinite, and that the occupier must seek to end the occupation and return the territory to the sovereignty, which is the people under occupation, as soon as reasonably possible. The third point is that during the occupation, the belligerent occupier is to act in the best interests of the people under occupation, i.e. restoring their economy, protecting their social and religious values, adhering to their particular laws, respecting their property rights, and preparing, if you like, for the restoration of sovereignty in the hands of the protected people. And fourth and finally, the rule is that the belligerent occupier must administer the occupied territory in good faith, including acting in full compliance with the directions of the international community and integral bodies like the Security Council and the General Assembly. And my point is that this has not happened. Each of those four fundamental principles has been breached by the now 54-year-old occupation of Israel. And we have moved a long time ago from seeing what Israel is doing as a means of complying with those four fundamental principles governing the behavior of an occupying power to developing effective tools of control in order to maintain indefinite, indeed permanent control over these lands, such as building settlements, of having 250 settlements in occupied East Jerusalem and the West Bank, with around 680,000 Israeli settlers, of having significant commerce and investment, not only in the settlements and the settlement economy, by developing and entrenching an unequal legal system between these that governs the settlers versus what governs the Palestinians under occupation. And of course, as an integral part of that, the topic for our discussion today, which is the existence and application of the military courts. Military courts could be in the hands of an occupying power acting in good faith, in consistency with the four principles that I've mentioned, could be a legitimate tool for ensuring security during the short period of time that is occupying the territory in preparation for returning the territory back to the occupied population. But in this case, it's evident by the use of the military courts, all that's detailed in this excellent report by War and Want, that what Israel is using the courts to do is a tool to maintain permanent rule over the Palestinians and to try to subdue a perpetually rebellious population that has never wanted, and certainly today does not want, alien rule over it.
Yeah, thank you. You know, I'm speaking to you from occupied East Jerusalem, and just hearing you talking about the annexation, the temporality, the best interest and administration, and you see the power of the military regime, like on the daily life, on the lives, on the work, on ability, on education, on the development, as something that Sahar was talking about. And I think that we need to keep that in our mind, knowing that the annexation is becoming part of the right of the and affected by the biblical claims of the state. So this is a different occupation, and military occupation is there to serve other means of the settler colony. Let me go back to Chichi and to ask you, you have written the report, and one of the things that you've written in the report is about the historical roots of the military court system. Can you really take us a really short journey into the relevance, especially the relevance in the British context? Can you speak a bit about the historical element?
Yeah, so one of the legal bases that Israel uses for military rule is legislation that was originally enacted by the British government in Palestine in 1945. This is called the Defense Emergency Regulations. The British mandate in Palestine was established in 1920 as part of the dividing up of the former Ottoman Empire, and it gave the British colonial rule over Palestine. The British ruled in Palestine until 1948. In this period, there was always Palestinian anti-colonial resistance to British rule, and by 1936, this had intensified into a full rebellion. So in 1930, the British administration introduced the Palestine Defence Ordering Council, which empowered the British High Commissioner to enact extraordinary and discretionary security regulations to suppress the ongoing Arab revolt. These ad hoc regulations granted powers to British forces to ban the publication of books and newspapers, to impose curfews, and the deployment of administrative detention. And as we know, as Sahar has talked about, administrative detention is still a central feature of Israeli rule in Palestine. It's also been used by the British ruling forces throughout the British Empire to stifle political dissent and incarcerate political opponents. And it was no different in Palestine. So by 1945, many of these regulations introduced in this period were codified into the Defence Emergency Regulations, and this included the establishment of military courts to arrested Palestinians tried by British forces in this time. When British rule in Palestine ended in 1948, this paved the basis for the creation of the State of Israel and the ethnic cleansing of historic Palestine that went along with it, what Palestinians call the Nakba, or catastrophe. Over 800,000 Palestinians were forcibly displaced at this time, and hundreds of Palestinian villages were depopulated and destroyed by Zionist militias that would later go on to form the Israeli military. So following its establishment, Israel adapted and codified the British Mandate's defense regulations into its own law. As the State of Israel was establishing itself and its first laws, it developed a code of civil law for its Jewish citizens, but kept the defense regulations to impose military rule internally on Palestinians who had managed to remain in their homeland. The defense regulations were then used to govern Palestinian citizens of Israel until 1966. So in 1967, Israel captured and occupied the remaining bits of historic Palestine, forcibly displacing over 300,000 more Palestinians and bringing over 1 million Palestinians under Israeli military control in East Jerusalem, in the West Bank and the Gaza Strip, what we call now the occupied Palestinian territory. So the Israeli army then immediately issued orders that kept the defense regulations operational in these areas, and since then has used these laws to criminalize and repress Palestinian and civil and political life. Following the annexation of East Jerusalem and the official disengagement from the Gaza Strip, today this only applies to the West Bank. So it's really important to remember this history this came from, not only to keep in mind British complicity and the responsibility that the UK government has today, but also to recognise that Israel as a structure and a set of practices is actually part of a much broader, older and a global project of European settler colonialism. So it's not enough to simply attack the outcome itself and see it in its totality, and to see the occupation as very much embedded in this history and part of it. So the situation in the occupied territories, so the settlements, the military courts and the siege on Gaza, they're not just a series of disparate rights violations, but they're part of a settler colonial project, which is not unique to Israel, but manifests itself in these particular ways. Yeah, I'll stop there. Thanks.
Yeah, I think that, looking at the history and contextualizing and historicizing the situation is very important. And looking at the Nakba and what happened before the Nakba, during the Nakba, the use of the military system to control Palestinians in 1948, then in 1967 is really major in analyzing where do we stand today. But moving to Attorney Sahar Francis, and asking you, let's move to the present day condition. Let's do and see. Today we have the Palestinian authorities legal system that is there. So how does the PA legal system fit into the picture of the Israeli military rule in the West Bank? And what about the settlers? We have the settlers that are subject to the Israeli civil law. How does these legal regimes fit together or not in the West Bank? What is happening in the West Bank? Are there different legal systems? Are there separate legal systems? Are there conflicting legal systems? Are those conflicting legal systems playing to the hands of the sovereign power? Can you give us your insights?
Thanks for this question, Nadira. I think this is totally fits in the point of Professor Link about the whether the intention was really to end this occupation or to maintain the occupation forever. Because I think when the Israeli side signed the Oslo Agreement with the Palestinian Authority, unfortunately, they were worrying about every small element and aspect of the legal status and the legal ability of their military court system, because they kept this jurisdiction even over the what was called so far Area A, the supposed to be the core territory for the state of Palestine. The Israelis kept the jurisdiction of their military courts over these areas. And actually, after the second Intifada, I don't think anymore we can talk about Area A, B, and C with this separation in jurisdiction and power. Actually, the reality on the ground shows that the Israeli occupation forces are raiding the Palestinian main cities on daily basis and arresting tens of people every day and bringing them to the military courts. And actually, there's more than that, when we think about what was going on in between these two authorities in the last couple of years, the security arrangements that ended up, unfortunately, with arresting Palestinians by the Palestinian Authority for political affiliation. And when they were released, they were immediately arrested by the Israelis based on the same more or less allegations, or the way around. Actually, the legal situation in this issue could be more complicated, because Israel is still using the legal regimes that were before even the occupation of 1967, and relies on them in some points in the military system. For example, the land confiscation issue, when they are still using the Ottomanic law in order to justify that you didn't worked in your land for the last continuous 10 years. And this is a reason to confiscate personal property and then to use it for settlements or for military and so on. And at some point they also used and this is an irony, that they used some of the definitions of the Palestinian revolutionary laws of the 70s, or the way around that the Palestinian Authority used some of the military orders when there was Illegality in the definition of the Jordanian criminal law of 1964 that is still applicable on the occupied territories. So the legal actually the legal situation is complicated, but I think the main point here is really to highlight the point that Israel, I think, were never aiming to end their occupation, but the way around, to maintain the hegemony and the control over the Palestinians, and to use all, because they don't respect even the decisions of the Palestinian courts. If someone, for example, from Hamas affiliated political party is sentenced in the Palestinian Authority for his political activism and he would be arrested by the Israeli military system, the military court would never consider that this is double jeopardy and that they should take in consideration the fact that he was arrested by the PA. It never counts when people are arrested from both sides. On the settlers' point, and this shows how the apartheid regime works actually, with all this number of almost 600,000 settlers, none of them, they would be prosecuted in the Israeli military court if they commit a crime that is considered to be a threat against the security of the state or the security of the areas, or even if they kill a Palestinian and attacking Palestinian, they would all be prosecuted in Israeli civil system. Not more than that, and I would end by this. When we claim that there's a kind of annexation, when we review the amendments for the military orders and the new procedures that they amend to the system, it's all taken from the Israeli criminal code and criminal procedures, but whenever it fits their purposes. So, for example, one of the defenses that was developing by presidential cases in Israel to become lately part of the law about the self-defense when you face a attack against your property and you want to defend your property and you injured someone and you killed someone, you have a protection under the Israeli criminal law. It wasn't adopted by the Israeli military when they adopted most of these protections, of course, in order to protect settlers and there is an increase in the last couple of years by the settlers' attacks against Palestinian farmers, property, and it takes place every day. And actually hundreds of complaints that Palestinians fell against the settlers' attacks ends up without any accountability, without any further investigation by the Israeli occupation forces.
Yeah, thank you, Sahar. I think that you're so right about it. When I look only at the case of Dima Lawawi, that her family was suffering from the attacks of the various settlers, and then the way she was arrested as a child, as a 12-year-old child, and was prosecuted in the military court. You just think how the two systems are working in different ways when the settlers are those that are attacking families. And of course, you know, my work on price tag looks at the different modes of creating the legal system and playing with the legal system in order to serve the state and not the other way around. I want to move to Professor Michael Link again, and to engage you with the report, because in the report by Warren Mont mentions that targeting human rights defenders is a particular pattern of concern. And you and fellow UN human rights experts have been compelled to make statements in the past months about the repression of Palestinian human rights defenders and the role of the military courts. Can you really speak to this issue?
Happily. Again, another one of my reports a couple of years ago focused on human rights defenders. And if I can give kind of a global overview of the protections that international law tries to extend to these defenders, and then I'll speak about one particular case that I commented on a few months ago. When we look at international law, we can see that the international community, speaking through the United Nations, has taken seriously the kind of work being done by human rights defenders around the world. Indeed, there are many very good statements coming from my fellow Special Rapporteur, Mary Lower, who is the Special Rapporteur on the defense of human rights defenders. And why do we do this? Well, I've come up with at least 4 reasons why. First, you know, the work of human rights defenders is often the best and sometimes even the only protection available to vulnerable and marginalized people. Secondly, the activities of human rights defenders are critical for ensuring that governments and private actors can be held accountable for their behavior, both to the citizenry and to the conscience of the world. Third, the actions of human rights defenders often place them in situations of danger and vulnerability with respect to their own rights and safety. And fourth, the condition of human rights in any country or conflict situation can often be effectively measured by the respect accorded to practices of human rights defenders. So while I won't take you through the law that has been developed over the last 40 years with respect to this, I do want to point everybody to Resolution 53144 of the General Assembly, which was passed 20 years ago, where the General Assembly of the United Nations adopted by consensus the Declaration on the Right and Responsibility of Individuals, Groups, and Organs of Society to promote and protect universally recognized human rights and fundamental freedoms. And what it says among other things, it says 3 important things. First of all, it calls for the effective elimination of all violations of human rights and fundamental freedoms of peoples and individuals, including in those with respect to the foreign domination of an occupation. Secondly, it says that the prime responsibility and duty to promote and protect human rights and fundamental freedoms lies with the state. And thirdly, it says that the right and responsibility of individuals, groups, and associations to promote respect for and foster knowledge of human rights and fundamental freedoms lies at the national and international levels. So there's been a long-standing pattern of behavior by Israel with respect to both Palestinian as well as Israeli human rights organizations that are working to defend Palestinian individual and national rights and to defend the concept of Palestinian self-determination. And a couple of months ago, I issued a statement together with Ms. Lawler, the UN Special Rapporteur on human rights defenders, with respect to the case of Issa Amro. And he is but one of the example of many Palestinian human rights defenders who has been prosecuted through the Israeli military courts. He was convicted 2 months ago for his work with Youth Against Settlements in Hebron. He was convicted of 6 charges relating to his human rights activities between 2010 and 2016, such as participating in demonstrations without a permit, obstructing security forces, which included an alleged refusal to accompany Israeli law enforcement officers during an arrest. In our view, his conviction appeared to be politically motivated, and we said this conviction is part of a pattern where Israeli military law is being used to restrict and penalize Palestinians for exercising their inalienable political and civil rights. And we noted that Article 21 of the 1966 International Covenant on Civil and Political Rights guarantees the right to a peaceful assembly. And we also noted that the Human Rights Council's comment on Article 21 states that the failure to notify the authorities of upcoming assembly where required does not render the act of participation in an assembly unlawful. And what we concluded, and this is, I will quote directly from our statement from 2 months ago, we said that the Israeli military court system in the West Bank is deeply flawed and has been repeatedly used to silence human rights defenders. The system follows a vague interpretation of offenses and military orders which fail to clarify what conduct can result in criminal offense. So therefore, what it leaves is an extraordinarily wide area of discretion in the hands of the military itself, as well as the military prosecutor, on who to target and who to then wind up charging, convicting, and indeed even imprisoning.
Yeah, indeed, it is that discretion that allows the system to function in so many ways, and we've seen it in during the 8th March on the International Women's Day, where there were some activities by small groups of community centers, and a woman was arrested because there was an embroidery, and on the embroidery it was embroidered that our heritage is resistance. It's Turath wa Muqawami. And over this, so it goes back to what the Sahar was saying and what you were saying, is that, the question is how can we really curb and hinder the power and the discretional power that the system is allowing. Okay, let me move to Sahar again, to Attorney Francis, and ask you. You have really written in your recent article in The Guardian that your experience defending Palestinians in military courts has shown you that it is a system that cannot be reformed. I'm quoting. Can you describe the challenges that yourself and other defense lawyers have encountered, and what has compelled you to say that it's a system beyond reform?
I think there's so many examples that I can bring, but the first thing jumps to my mind as an answer for this question is the case of the Palestinian Legislative Council members who were arrested back in 2006 after the Palestinian election and the claim of Israel and the rest of the world that Hamas won the election. And actually, at one night in June 2006, Israel arrested more than 48 Palestinian Legislative Council members. They were all brought to the military court, that they were keeping them in detention and then to be charged under the 2 charges of being members of illegal organization and aiding illegal organization. And what was the organization in the charge sheet? The list of the reform and change that was not declared by itself at that time as illegal organization. How the argument was built in the charge sheet. Israel claimed that the reform and change list is belonging to Hamas. And this is how they made it illegal. They declared the party itself as illegal a year after the case. And we picked 2 cases, me and another colleague, another lawyer, that we took the strategy to exhaust all the procedures in this military court. And we succeeded in the first instant court to prove that not every Hamas member or not every member in the charge and reform is automatically considered a Hamas member. And actually they were acquitted from the illegal membership. But then the military prosecutors appealed, and the military court, the appeal court, found the legal way how to justify that every member in this list is Hamas, and they were sentenced for 3 years and a half. And this is one simple example of the struggles that we face as lawyers. We mentioned administrative detention. Can you imagine how you are able to defend a boy like Amal Nakhli, that he's suffering from a very dangerous illness, myasthenia gravis, that even the doctor in Majiddo prison admits that in any case of serious infection, the guy could die, especially under the corona situation. And still the appeal court reduced his detention from 6 months to 4 months. As a defendant lawyer, you're tied and you don't have enough tools. Every legal tool that you try to exhaust, there is an answer. And as I said, security can justify everything. So they can find, and as you said in your introduction, they made everything legal. Looks that it's legal according to the, but it doesn't respect, of course, the international standards. And this is why I totally take the theory of Mr. Link that it crossed a red line. And this is actually why we are calling for abolition, that there's no way how you can seek justice under this system. And the case of the children and the fact that they declared about a special military court for juveniles in 2010 actually is a perfect example of how they take the pressure and make it as it looks like legal, but in fact it doesn't protect the children's right and doesn't make safeguard for the children from all the violations that they are still facing under this system. And this is why I don't believe that we can make this system looks better or more just. This system is used as a tool by the occupation. The occupation should be end, and with it should be dismantling all the military courts and releasing all the Palestinian prisoners.
Yeah, actually, the case of the children is a really very interesting case because it shows how they use the best interest of the child and they separated between the adults and the children. When adult Palestinian prisoners used to support the children, and this separation between the two created an additional problem and left the children in a very, very, very fragile and vulnerable condition, something that Professor Viturbo from Queen Mary talks about and writes about. And it's really worth, and thank you, Sahar, for mentioning it. Let me just go with the final question to the three of you. Each of you have, it brings a particular set of experience and particular set of perspective. Can each of you comment on what can be done? Because under the condition that you were describing, Attorney Francis, one of the things that I see is that it's no matter what you do, the system is there to serve the sovereign power and is there to further dispossess. So you are running and rushing and helping and lawyering in the court, but going back to Lisa Hajjar's analysis and to others, can you continue? So what can be done? And Chichi, what action should be taken by the UK government? Maybe this is the time to go to international and global players. And Professor Michael, what is the recommendation or the recommended for the international community more broadly? Can you really tell us more? How can we act? Because when you were talking about, the importance of human rights defender, their critical role, they are the only ones, the danger they go through. I kind of go back and think, is it really helping us, or is it giving Israel another way to tell us, here you have human rights defender, so stop claiming that Israel is not doesn't have an open the space is open to discuss and to, you know, present a report like our report today. So can you really help us understand and whether Sahar, what kind of actions are Palestinian groups like Ad-Damir taking beyond the day-to-day work? How can we be supported as Palestinian organizations that are working so tirelessly for so long on a topic that, just listening to you today and hearing your journey for such a long period, how can we do it differently? Chichi, you want to start?
Yes. Yeah, so I mean, we would say that the UK government has a responsibility not to grant Israel any more impunity than it already has. And so from our report, the recommendations are, firstly, and this will come as no surprise to anyone really, implement a two-way arms embargo on Israel. And so the UK government has its own export licensing controls, which prohibit arms sales to countries where they'll be used in human rights violations and violations of international law. And, you know, as we've seen from like multiple years of research, this is Israel. And so technically, arms sales to Israel should be banned under its own export standards. Specifically in the context of military courts and arrest and detention, when the Israeli army conducts arrest raids, when they repress protest, it's like armed Israeli military that are doing this, and they are in effect being aided and abetted by the UK government. So approved export licenses from the UK to Israel have covered components for small arms, ammunition, night sight technology, intelligence software, and other types of items that are very regularly used in Israel's system of arrest and detention. So this should end. And so the second one is to suspend the UK's judicial exchange program with Israel. And so Israeli military courts can't be disentangled from the judicial system within Israel itself. And so Sahar talks about this a bit when talking about torture, and how the Israeli High Court has actually consistently legitimized the use of torture by Israeli interrogators. It also legislates for the Israeli Prison Service and the Israeli Security Agency and the treatment of Palestinian detainees. The Israeli civil courts also have the power of judicial review of the military court system, even though petitions that are brought against them by Palestinians are overwhelmingly ruled against. The vast majority of Palestinians are also unable to access this mechanism in the first place because of the prevalence of plea bargains within the military court system and the costs associated. So in reality, the judicial review system just becomes a way of legitimizing the military courts by providing this sort of like veneer of accountability, when in reality, it's not accountable at all. So the UK judiciary does exchanges with the Israeli judiciary system as part of an exchange program, which is supposed to facilitate conversations and learning between UK judges and their foreign counterparts. Its participation in this gives the Israeli judiciary legitimacy, even though it keeps implementing occupation and apartheid. So this should end. And so the third one and the last recommendation is to increase support for Palestinian human rights defenders under attack and prosecuted in Israeli's military courts, and for Palestinian human rights organizations monitoring abuse and advocating for the rights of the Palestinian people. So again, the UK government has its own policy on human rights defenders, which is non-statutory, but it pledges support for human rights defenders under attack. We'd like to see this applied to Palestinian human rights defenders who, as Michael has talked about, in recent years have been increasingly targeted by Israel. So two of our recommendations are about the UK suspending its current involvement in systems that are fundamentally illegal. And the last one, increasing support for Palestinian human rights defenders, is something that we'd like to see that is a proactive and positive step towards justice. Thanks.
Thank you, Gigi. Yeah, can I move to Attorney Francis?
Yes, I think we totally support the recommendations that were brought in the report of War on Want, but to add on, of course, Damir lately launched as well our own campaign against the military court system, and we're trying to increase the awareness even locally against the system. We do understand that in the daily level, we cannot stop representing immediately Palestinian prisoners in front of this system because there's no other alternatives. We have to continue to represent Palestinian prisoners in front of this system, but in the same time, and this is why this campaign is very important for us, because in the same time, we are trying to raise the awareness and we're trying to push for reviewing this system in a different way as part of the apartheid, as part of a war crime and crimes against humanity. What's going on in this system should be clearly described as part of the grave violations for the 4th Geneva Convention. And this brings the framework for the responsibilities of the states that they are parties to these international treaties, and they have really responsibilities. And I'm sure that Mr. Link maybe will elaborate more on the third state party responsibilities under international law in order to put an end for the occupation and as well to end the use of the military courts. So I think every activity that international lawyers, international activists, international organizations thinks that it can support our campaign and our argument that it should be like it's the time for accountability. And what was recommended in the report versus the UK government on the embargo on the armed to the Israeli army could be correct for every state that is actually having these relations with Israel, because we shouldn't be complicit with torture, with unfair trial procedures, with all these grave violations to the 4th Geneva Convention. Thanks.
Thank you, Sahar. Yeah, Professor Link, and I would also like you maybe to engage with a concern of mine when I was hearing the different perceptions, is that the issue of how can we really fight the secret information when secret information is really violence and it creates all sorts of carceral strategies of isolation, of entrapment. How can we really, as human rights defenders, as people that are working in the legal against what is going on, how can we really discuss it and look at it from and fight it? Because this is what I see as something that is core to the functioning of the military court when they come up with, oh, there's secret information, and lawyers and defenders and parents and families and individuals' lives, the students from Birzeit University that were unable to reach their universities or their ability to develop and study was hindered. So how can we really, it comes to my mind, the analysis of some of the Deleuzian scholars on, it has this swarming effect. It comes into something, it attacks it, and you don't know how to look at it, how to analyze it. And the legal system is failing us in so many ways. So what can we really do in addition to what is being done in here to stand against such unending and accumulative dispossession?
Thank you for that, Nadira. I'll come to that at the end of the answer to the question you originally posed to me about what can the international community, what should it be doing? I always start from the premise that Israel is a small country. It's 9 million people within its 1967 borders, and there's 14 million people in total whom it controls between the Jordan and the Mediterranean. Israel is heavily dependent upon diplomatic, economic, and military support from the international community, particularly, obviously, the United States and the European community and the UK. This occupation would not have continued as it has for 54 years without either the active or the benign support of the West. And all we have to do is look at the $3.8 billion of military aid given each year by the United States to Israel, and the fact that 40% of Israel's external trade is with the European Union. Now, notwithstanding the many critical resolutions that have been adopted by the United Nations through the Security Council, the General Assembly, and the Human Rights Council, Western countries in their foreign policy tend to treat Israel as a normal, even special country, with perhaps an errant and regrettable policy towards the Palestinians in the occupied territories that should not stand in the way of a deepening and friendly relationship. It's obviously my view with respect to the issues of accountability that there's never been there's no conflict in the modern world where on the one hand there is such a rich array of legal statements and legal analysis by the international community talking about how so many facets of this occupation are in flagrant violation. That's the UN's word, flagrant violation of international law, starting with the settlements. And yet there's been so little attempt at accountability. Accountability, in my view, is the missing key to opening up this titanium cage that is the occupation. And Sahar has mentioned, that there are a facet of international accountability tools that govern the behavior of the international community towards a conflict zone like Israel and Palestine. That includes Common Article number 1 of the 4 Geneva Conventions, which requires all of the high contracting parties, which includes virtually every country in the world, to not only respect the obligations of the Geneva Conventions, but to ensure respect by other high contracting parties. Second, there's the 2001 Articles on State Responsibility that were adopted unanimously by the General Assembly, which require cooperation by the international community to bring a grave human rights situation to an end. And thirdly, there's Article 25 of the Charter of the United Nations, which requires every member of the United Nations to obey decisions of the Security Council. And there are, I've counted, over 30 Security Council resolutions dealing with annexation, dealing with the settlements, dealing with the application of the Fourth Geneva Convention that have been adopted by the Security Council since 1967 that Israel is in violation of. Indeed, in some of these resolutions that were passed by the Security Council in 1979 and 1980, when the occupation was only 12 and 13 years old, it's citing Israel for not obeying previous Security Council resolutions, not obeying the direction of the international community, and saying that it is now prepared to take more interventionist stance towards Israel to ensure compliance. And here we are more than 4 decades later, with the occupation more than 4 times in length of time, and nothing has been done with respect to this. If I can sort of end this part off by saying, I'm in the process in one of my upcoming reports of developing criteria for measuring whether or not a state, an international organization, or some other body is actually taking real steps in order to be able to end the occupation, or that it doesn't go much beyond lip service with respect to calling for an end to the occupation. Here are the 5 criteria that I'm going to be looking at. First, that the framework for governing the occupation and the end of the occupation has to be within international law and human rights. It cannot be sidelined. It cannot be marginalized. Secondly, the end goal must be genuine Palestinian self-determination. Thirdly, there has to be, as a cornerstone, that Israel is and has been a bad faith occupier for the reasons I mentioned in one of my earlier answers. Fourthly, because of the vast asymmetrical power between Israel and Palestine, active international intervention is indispensable to ending the occupation. And fifth, the occupation has to end with all deliberate speed, has to end fully with all deliberate speed. If an organization, if a state, if a body is not complying with those well-accepted factors within international law, then it's actually aiding the continuation of the occupation rather than being a force of change to bring the occupation to a complete end. And you've asked me, Nadira, with respect to secret information in military trials. This is obviously contrary to any modern understanding of how any court system works, including military trials. Just because it's a military court in an occupation doesn't mean that it's free from the standard obligations of what constitutes a fair and full trial. Keeping information, secret information, from the defendant, not knowing what she or he is being charged with, not knowing the details of the alleged impropriety of the activities they're involved in, violates every fundamental norm that we know of with respect to the conduct of criminal justice in the modern world. If I can make a pitch for a recent movie that I've just watched, which has just come out, I urge everybody to watch the movie The Mauritanian, which has to do with the imprisonment either for 14 or 16 years of one of the Guantanamo defendants, starring, among other people, Jodie Foster and Benedict Cumberbatch. And I don't think it would take too much in terms of a person's imagination to be able to draw lessons from the treatment in Guantanamo and its use of secret information against the detainees who are never charged, let alone tried or convicted, with saying that there are many elements that are shared with respect to the military system in the occupied Palestinian territory.
Yeah, it's also a topic that I'm researching and listening to the stories of the people and listening to Sahar talking about social media and the way, they come up with all sorts of secret information, and looking at academic production in different places that are checking the lone wolf and studying others. It's really important to discuss this issue more extensively. Let's look at the Q's and A's, and we have some time for it. There is a question by Patricia Kaminsky, and the question says, what is the international community so different? Why is the international community so indifferent or so scared of Israel? We seem to be more busy defending Israel's state, trying to make divestment illegal, US saying they will not recognize the ICC investigation. And another question by Teresa Bailey. Are human rights lawyers and organizations in Palestine, Israel targeted by Israel? And let me stop with those two questions and ask Sahar maybe, or Professor Link to answer, or Chichi, if you have any reflections to the first two questions.
If I may ask that Mr. Link goes first on these.
Let me try to answer the first question that you mentioned, Nadira, with respect to Israel. I usefully read parts of Barack Obama's recent memoir, A Promised Land, and he has a long partial chapter on his involvement with respect to Israel and Palestine during the first term from 2009 to 2013, and surprisingly and interesting, he has some extraordinary insights, which I think can wind up helping us understand this. He said, it should come as no surprise, but it is interesting coming from the mouth of a former president of the United States, that there was no foreign policy issue that he dealt with in his first term of his presidency that involved so much domestic involvement, so much political pushback as the issue of Israel. He said, in the whole range of important foreign policy issues that I dealt with, China, Russia, the European Union, Canada, Africa, nothing compared to the amount of time that I would have to wind up spending with respect to domestic opposition to putting any meaningful pressure on the Israeli government to adhere to international law. Actually, he didn't use that term, but to its own international commitments that it had under the roadmap, for example, and other international documents developed since the 1990s. And what he said with respect to the United States, I'm sure is equally true with respect to domestic pressure on a foreign policy issue that you would find in the United Kingdom, you would find in my country of Canada, that you would find anywhere in the Western world. There are particularly effective lobbies that organize around the position of not putting any daylight at all between a Western country's foreign policy and what Israel is actually doing on the ground. Yes, there may be at times polite differences of opinion expressed by Western countries with respect to Israeli policy. Yes, there may be musings about wanting to draw bright red lines in the sand with regards to this. But in particular, over the last 10 months, once the issue of formal de jure annexation was taken off the table in the late summer of 2020, there was an enormous audible sigh of relief by European and Western countries that the issue of Israel and what its mistaken policy is going to wind up producing for us is now off the table, with no commentary, with no recognition that de facto annexation continues as before. Indeed, in 2020, there was the highest number of settlement housing unit approvals any time since Peace Now was keeping these numbers since in beginning in 2012. So if there was a Israeli foreign policy failure in securing formal de jure annexation recognized by the United States, the former Trump administration, was now off the table, it doesn't mean that the de facto annexation, which was equally illegal under international law, is not still continuing.
Thank you.
I'll take the second part because I totally agree with what was Professor Link saying on the question about the attack against Palestinian human rights organizations, correct? This is, yeah. Of course, we are facing daily attacks because of our work as human rights organizations, especially those that they are trying to do the work versus the ICC and on the international level and bringing this question of accountability. And the attack includes smear campaigns that we are terrorist organizations ourselves, and by different forms of, it could include physical attack to the organization's offices and breaking into, causing mess and stealing laptops or memory cards or whatever information they want. And also it includes lots of restrictions on the people who works on the organizations, like imprisonment or banned travels, or asking someone that, like house arrest in some cases, or controlling the ability of the movement to one city, or just in Jerusalem without being able to enter to the West Bank and so on. So there's so many different ways how human rights organizations and human rights defenders actually could be attacked and harassed by the Israeli occupation.
Yeah, Chichi, would you like to say something?
Yeah, just quickly to add on to what Michael and Zaha have said. With regards to the international community, I think it's important, as I sort of said earlier, to see this within like the whole light of like a global project, and the fact that it's we see that oppressive states across the world like learn from each other and actually work together in various ways, and then also here like the rights that we have can't be taken for granted. And actually it's, I think, not just a question of repression overseas, but we have to see as well how it starts from home, and how, you know, like I was saying, like the UK is very complicit also in terms of the rights that we have as citizens here. And again, so like like War on Want is very concerned about the increasing shrinking space for civil society in Palestine, and also the advocates of Palestinian rights in the UK are facing here. And yeah, we've written about this a bit as well, and I can link to our Defenders webpage if people would like to see more about this issue. Oh, Rivka has. Cool. Thank you.
Well, we have 2 more questions. I'll read them and then we'll try to conclude. Anissa asks, isn't it past time to change the discourse to finally address the root cause of the problem, which is pure European settler colonialism? And certainly not simply military occupation, which is just a means that the settler colonial regime is using to achieve its goal. And Mushtaba Musavi asks, MPs consistently say they are against human rights violation in military courts, particularly toward children, but they maintain a 2-state solution is the only solution, and so they will continue negotiating for peaceful solution, thereby granting legitimacy to the regime. Is the 2-state solution a block to Palestinian freedom? And if so, do we need to make a firmer stance against Israel's occupation and call for a 1-state solution? It's open to you.
Let me briefly jump in, but I want to make sure everybody's got the time and in the few minutes we have left. Here's my point. As a special rapporteur, I take no position with respect to a 2-state or 1-state solution. Both, I think, can be consistent with international law. But what I worry about is that the 2-state solution has become a hollow mantra to be repeated endlessly by Western foreign ministers as a substitute for taking any meaningful action to impose the kinds of costs that Israel has never faced, in order to try to bring this occupation to an end. This occupation is not going to die of old age. It will only end when there has been meaningful and decisive intervention by the international community to bring it to an end. Palestinians are calling for that. Certainly Israelis of conscience are calling for international intervention as well, because they see no ability with the huge disparity in power between the two on the ground of that ever coming to an end simply through negotiations by the 2 parties themselves.
Thank you. Thank you. I think that this point should really be taken into consideration very seriously, because without really a global intervention and international intervention to change the flagrant violation, it's really, the situation can continue. Yes?
Exactly. I think this brings me also to the issue that honestly, we don't need to give our position 1-state or 2-state, but rather to highlight the urgency of ending all these international violations for the international law, whether in the occupied territories, 67, or inside the state of Israel, because we never discussed the nationality law, for example, that says it's a Jewish state with all the consequences for such a law on the daily life of the Palestinian people who are citizens of the state of Israel, and how it established a apartheid regime. So I think it's very, very important to be highlighting more the self-determination, the need to really seek the self-determination of the Palestinian people, with all the responsibilities on the international community to support Palestinians to reach the self-determination, irrelevant to the solution, 1-state or 2 states at the end of the day. And just to reflect on the first part that was, remind me again, Nadira, sorry.
You want me to read? Isn't it past time to change the discourse?
Yeah, so I think, yes, it's, it's really the time to take the reality more to the, but I think what's going on in the international level, unfortunately, is double standards when dealing with the Palestinian cause. I think it's it's not the problem of material or facts or evidences that we have in order to show that the reality is much more than occupation and military control, but more than that. And this is why I agree that, yeah, it's the time to change as well the vocabulary that we use.
The discourse. Thank you, Sahar. Chichi, do you want to say a word? Because we are already past 1 minute.
Yeah, just really quickly. Speaking from War on One and the position of like Palestine solidarity in the UK, it's not for us to prescribe any kind of solution or whatever to this, but just to support Palestinian self-determination, as Sarah and Michael have said, and also to focus on ending the UK complicity in Israel's human rights violations.
Yeah. Okay, thank you very much. I want to thank everybody for being here. I think that the report have really, and I would ask you to go and read the report on the military court. I want to thank Professor Michael Link, Chichi, she, and Attorney Sahar Francis for sharing with us your reflections and your analysis. And I really think that it's time to really call for accountability, as we've heard from you all, and for international intervention, and to remember that this is a system. It's a settler colonial system that is a structure. It's not an event here and event there. It's about the indigenization of the Israelis and the eviction of the Palestinian, and it's embedded in a logic of elimination, and therefore the need to really take those issues in consideration and stop the human suffering in Palestine. Thank you again for joining us.
Thanks a lot.
Thank you.